So it's like, it must be, hands that officers put out there.
A broken relationship leads to system rage. Witness the tense hearing as Mr. Ethelberger faces the Property Association report and returns to public service. Will the judge accept the explanation for the property wildness, or will he limit the action beyond this? Don't miss the unexpected developments in the project room.
Mr. Louis Ethelberger.
Come on up. All right, so you are Mr. Ethelberger.
Yes, sir.
So you're charged with two cases. You're charged with interference with the duties of a public servant. You're also charged with criminal mischief. In those cases, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present. If you cannot afford it, one will be appointed to you, sir.
Yes, sir.
Thank you, Judge. Judge, law enforcement officers were dispatched to a disturbance call in Harris County, Texas, and made contact with a complaining witness who stated that on April 28, 2025, she observed a prior resident, the defendant, caused damage to the apartment complex after a breakup with a significant other. The complaining witness said that the defendant broke 3 flower pots and damaged 3 trash cans for a total of $405 worth of damage. On April 29th, the defendant came to the leasing office and demanded property that was left. The complaining witness asked the defendant if he was the one that caused the damage. The defendant stated he was not. Complaining witness and a witness then tried to get the defendant to leave due to him causing a disturbance. The defendant pushed his way through complaining witness and a witness. A law enforcement officer on scene serving civil papers attempted to detain the defendant. The defendant was able to get away and run from that law enforcement officer. The defendant was later detained when other law enforcement officers arrived on scene.
So the mischief, it's at an apartment.
That's correct, Your Honor.
His apartment?
I believe he was a prior resident of the apartments, Your Honor, and the property belonged to the apartment complex.
And that was my question this morning, Your Honor. I haven't stayed in an apartment in a long time, so typically apartment complexes don't give their property at a residence specific apartment complex.
You mean furnished?
Furniture, it's flower pots. I mean, why would an apartment complex have their flower pots out in front of a resident's apartment?
What all was allegedly broken again?
3 flower pots and 3 trash cans, Your Honor.
Are you saying it belongs to him? What are you saying?
I believe it belongs to him or to the partner, the former partner, the leases, the people that lease the actual
Because
premises.
if it belongs to the other person, then it's a criminal mischief. You can't break someone else's property.
But he's not the complainant. The complainant is the leasing manager for the apartment complex. They're alleging that the property belongs to the apartment complex.
Your Honor, from the DEMS, it says that each 3 trash cans were $35 each. They're placed outside for residents to use for trash bags on all 3 levels of Building 8.
So it's like, it must be, cans that officers put out there in case anyone needs to put trash in or whatnot. You know what I mean?
Yes, sir.
As far as the interference is concerned, that I may have a problem with.
I don't see how that was interference.
Because what would they possibly put him in custody for?
So, Your Honor, just to clarify, I'm not, what the DIMS say, and they go to great lengths to explain this, is that there was a deputy there who was serving some civil papers.
Sure.
And that he had to stop serving the civil papers to go
To chase him.
detain the tenant against the defendant. There was a disturbance in the leasing office. And at some point during that disturbance, the defendant got away from the deputy who was serving the civil papers.
Correct.
It's not really clear from the information, is the serving the civil papers and having to stop that duty to go detain the defendant, or is it the defendant getting away from the deputy, if that's what the basis for the interference is?
And that's correct, Your Honor. Richard and I spoke about that this morning.
So you don't think there's PC on the interference?
I don't think there's PC on the interference, honestly, either way. If he's trying to serve papers,
I think I agree with you on the interference,
yes, Your Honor.
but I think that there's PC to go forward on the criminal mischief.
Yes, Your Honor.
No?
I'll dump the interference.
So I'm going to find no probable cause to go forward on the interference. I don't think that they had a reason to, have you in custody or for what to interfere with.
Yes, sir.
I will find that there's probable cause to go forward on the criminal mischief. Is he staying there now or is he gone?
No, Your Honor. I think both individuals have moved away from the apartment
Okay,
complex.
so Mr. Eichelberger, the only thing I'm going to ask you now, or I'm going to order you, is not to go back to this place, not to have contact with the complaining witness.
I
Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond, not to be in possession of weapons as well. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Brock and he'll tell you if and when you have to come back to court. Just stay out of trouble. Don't pick up any new cases. I don't want to have to put you in jail.
I
You
understand.
become a danger to my community. It's not going to go well for you. You understand?
Yes, sir.
So for now, I'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it. And then after that, you're free to go.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes, sir.
Thank you.
Mark, do you have an arrangement?
No, you're still in arraignment? Okay.
Yeah. If you test positive one more time for anything, you will be looking at an inpatient rehab facility.
Welcome to the emotional building, where a young man's fate hangs in the balance between a second chance and pleading for mercy for his son, who's struggling with addiction.
Great to see you, Sonia. It's been a while. How are you? So we have Mr. Rucker.
So we have, done the paperwork for a deferred.
You have what?
We've done the paperwork for a deferred.
Okay. Is that what you want to do?
Yes, John.
Mom and Dad, you can come up. Or, hold on, guys. I don't know if it's ready yet. You okay?
It's Rucker's supervisions.
For what?
Fernandez. We will select the professional chief and he's trying to post the bond. They have it as a label. He has to. Yes.
Whoa, this is the one that we took in yesterday.
Yes.
Yeah. Do you have the paperwork ready on this property? No. All right. Come on up, guys. Thank you so much for coming, guys. You're entering into a very, you're entering into a very serious agreement now, Mr. Rucker. And if you think that the way that you've acted while you're on bond, it's gonna work like this while you're on probation, you're very mistaken. It's not going to. I'm telling you now, the agreement that you enter into, while it's great if you can complete it because you don't end up with a conviction, you give up nearly every right known to man by entering into this deferred. If you violate any condition, you were looking at an entire year in jail. Do you understand? So is he living with you guys now? Because I can't do this alone. While he's been on bond, it's been a veritable nightmare trying to even get him here. How are you going to be able to make this when you can't even make it to court?
So his situation has drastically changed. He has gone to inpatient rehab. He is currently in outpatient supportive treatment that he attends 3 times a week. He's been opioid free for 6 months now. He is working. He has his own vehicle, so things are very different. And he has moved back.
If I send him for a drug test now, what's going to happen?
I'm gonna show it for THC, but I'll make sure.
Unacceptable. No means no. I'm going to tell you, I want to send him to GRAS today. If you test positive one more time for anything, you will be looking at an inpatient rehab facility in the jail. It's a minimum of 9 to 10 months. If you respond well to treatment, you could be in there for about 1.5 years. If you continue to use. And I don't care what it is, whether it's CBD, whether it's oil, whether it's a vape pen, whether it's pills, whether it's a joint, I don't care. No means no. Do you understand? Mind over matter is what it amounts to. I cannot comprehend how you can let this thing take a hold of you so much so that everything else falls by the wayside. Mind over matter. That's what it's about. And if you ever have the feeling where I'm going to use, you either get in contact with us, you get in contact with probation, you get in just if you use, it could very well cost you about 1.5 years of your life next time. Do you understand?
Yes, sir.
Your Honor, he is receiving,
Suboxone is only something to prevent withdrawal so you don't go through the madness of withdrawal.
He's consistently on it through his outpatient treatment because his habit was so bad.
What was the drug of choice? Oxy? And all you need is the little amount of your pinky and it kills you. I can't tell you how many people we've had here that continue to take the pills, continue to take it because the tolerance builds up and you end up killing yourself because you put your lungs to sleep. That's what you do. Not to mention, it's expensive to even do this. How are you even getting the money to do it? Are you working?
So
What do you do?
perception.
Did you graduate from high school?
Yes, sir.
He's living with you now?
Yes.
Okay. While he's on probation, he must stay living with you guys. Okay. And I think that it's probably a good idea to have a curfew while he's on probation so that he's not out in the middle of the night. You are not allowed to hang out with any of your old friends. You hang out with the wrong crowd, you're going to end up doing the same thing. Now it'll be a part of the probation though, so that he has to adhere to it. And will adhere to we can make it a condition. Anything that you want, we can put it on there as well. So no weapons. If you know of a certain person that he's not supposed to hang around with, let us know. We can make that a part so he's not hanging around with these people. Can't go out at night. No going to any parties. No going to any bars. Hanging out with people who are either convicted felons or of a bad character. So I will let you guys get with Shatoria. You let us know, and then we can make it any kind of anything. What do you think is the appropriate time he should be home?
So we had him on, during the week, a 12 o'clock schedule,
At midnight? Oh, no.
That's only.
Work. Get off at 11.
So,
Houston Community College doesn't stay open until 11 o'clock.
but
Some
he has a
well,
lot of
afterwards.
girls. So,
But afterwards, like last week with the events, some days we'll stay after.
not often, but there are times where they have events, but typically the building. probably-
You will have to show what the event is, the time that it ends, and then you get approval. But 10 o'clock is your curfew. I don't want you to 10 o'clock. You take baby steps to earn trust. Trust isn't something that we just give to you. You have continually broken our trust. So I don't want you to do anything to drive you back into the old Mr. Rucker, because it's unacceptable. And the only thing we want is we don't want you to kill yourself. That's all we want. Everyone here, you have a lot to live for. Life is great. You know, the more money you have in life, the better life is. You get to buy nice things. You get to take nice vacations. You go on a cruise. You go wherever, Hawaii, wherever it may be. But that only happens with money. And you get money with education and with knowledge, not what you've been doing. The agreement that you have worked out is a 13-month deferred. This is a type of probation that, like I said, if you complete successfully, you do not end up with a conviction on your record. But like I said, you give up the right to a trial, compel witnesses to testify on your behalf, confront, cross-examine your accusers, right to be arraigned. You give up the right to appeal. So once you enter into this agreement, you are stuck with this until you either complete it successfully or you violate. You violate this agreement, I'm going to issue a warrant. I'm going to put you in custody, bring you back out, and we're going to talk about what you did to violate. And if you could be looking at an entire year. Do you understand? For you to complete this successfully, you must do a TRAS. This is an evaluation to see what other conditions you may need. If they assess supportive outpatient treatment, if they assess inpatient treatment, I don't know. But you understand. No drugs, alcohol, random testing, $100 one-time donation to the family violence provider. Just do Houston Area Women's Center. No weapons and no harassing, threatening, or abusive contact with Guajardo. Curfew 10 p.m. to 6 a.m. You must also do what's called the Batters Intervention Program. This is an 18-week class that you must go once a week for 18 weeks. Do you understand? The worst possible thing you can do is just take off. That's an immediate warrant. We can always work through any problems. And it's never about the money. I don't care about the money. It's you doing what you're saying you're going to do, staying out of trouble, and be nice. It's not hard, especially with these probation officers. You go to a probation officer, you make your appointment at 3:30 in the afternoon, you go over there, they're already going to be stressed out because they deal with all these other people. You go in there with a bunch of issues, it's probably not going to go well. You understand? Anything else you think that we should address? I'm going to waive all the fees, so it doesn't have to pay for anything. With regard to if they do any kind of like intensive outpatient, I'd like to try to qualify for funding.
Yes, sir.
You know, we're going to try to keep everything to a minimum as far as money, but you test positive. Do you understand? I want him tested today, and then let's test again in 50 days.
Okay.
I'm testing you again in 50 days. If you test positive for weed again, you know what happens. Do you understand? How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty, Mr. Rucker. I'm going to withhold that for 13 months. As part of this agreement, the assault is going to be the assault is dismissed, right? All right, Mr. Rucker, I wish you the best of luck. Make it work. All right, thanks.
Thank you.
Did you have a electronic monitoring device or just like the online system for the merchant?
You're charged with violation of protective order. You're facing up to a year in jail and or a $4,000 fine. The agreement.
A tearful plea and a chilling warning. Witness the tense moment as a young man stands trial for violating a protective order.
Hi, Ms. Strong.
Morning, Judge. This is Jonathan Lopez. We have a plea.
My only concern is that he goes back to mom and dad's house now. So what I'm going to do is I'm going to issue a protective order now over the complaining witness now, which is, I don't want you going back to mom and dad's house. You are not allowed to go back. You've repeatedly gone back. I'm issuing a new protective order now. You need to understand that you now you're pleading on this violation of protective order. I'm issuing a new one now. If you go back to the house, it's very well possible they charge you with a felony offense. Do you understand? I want to make sure that that family is protected and you don't have any contact with them. So I will accept this plea bargain agreement today, but I'm now issuing a new protective order today as well that bars you from going back to this house and having any contact.
I believe the protective order is for his sister, but then the
I thought it was
address
dad.
is the mother's address, so they're kind of conjointly protected in the same order.
Wasn't it? I thought it was dad. It wasn't dad.
The terroristic threat, I think that case involves with the brother and the mother. This VPO was at the mother's address.
Can you file another protective order today, please?
Yes, Your Honor.
In Mr. Lopez's case?
Yes, Your Honor.
So we put the complaining witness in this case as a protected individual and that he cannot go back to the house as well. No listed actions. Mr.
All
Lopez,
of his belongings have been removed from the mother's house, so he understands there is absolutely no reason for him to go back. They're currently at his uncle's house. I will make contact with uncle today to make sure that uncle picks him up upon release.
understand what's happening. What did we just say? Where can you not go?
Back to my mother's house,
Close.
my sister's house,
Right. What happens if you do?
basic felony.
Right. Have you been to prison before? Hey, you could be very well looking at a 15 to life case. How many times you been? Once or?
Wife,
So you could be a true habitual. You're looking at 25 to life if you pick up another one. 25 to life as a true habitual. If you go back, do you understand? Don't go back. You're charged with violation of protective order. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 210 days in jail with credit for the 57 days that you have done. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this, it will go on your record. It will be there forever. You understand? Is this what you want to do?
I do.
How do you plead to the offense of violation of protective order? Guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to it. I'm going to roll your report cost so you won't owe anything. Deputy, as you're going, please do not send him down because we need him to sign the protective order. Okay, all right. You know what's expected. Just don't. I mean, it's really going to be bad if you go back. Do you understand? That means no contact with him, Mr. Lopez. All right, sir.
Judge, I do have a question about the protective order. So I know they had amended one by hand, and that address has the mother's address, and then by name, it has his sister's name. Will we keep the address and name the same in the new protective order?
I think so.
Okay, okay, all right.
So he's going to have a ton of paperwork to sign. We'll have you go to Victoria Sign and Reset now.
A mysterious crash at Chick-fil-A and the quest for justice begins. Follow us as we uncover shocking details of a hit-and-run accident, and the only witness is the defendant's co-worker. Can the truth really be exposed? And can justice be served? Even if it's a low-key affair, let's find out what happens and what really matters at trial.
Just, I can't fix. Thank you.
Judge, I actually have two cases, but they're both off docket.
Okay.
One of them is, I'll give the cause number, it's 252-5198. This one, we were here on Monday, okay? He needed to get the interlock, but he was out of town. My associate was here. You said you bond forfeited him. You said as long as he gets the interlock.
remember. Yeah,
Yes.
remember.
And then he's already filed a supervision order, and so if you could just reinstate him.
Did he get the interlock?
Yes, and he's already filed a supervision order.
Ready to go?
This is on.
I filed it, Your Honor. We signed the contract, and I did file this.
Okay.
Yeah.
I mean, as long as it's good and you're.
It's filed it. I've already filed it. We probably should take part of you. And then we should.
Okay, I'll let her know that you reinstated it.
I did it yesterday, so.
Hopefully I did. I'll talk to her in a second.
Yeah, okay.
And my other one, Judge, is a walkthrough.
Gonna bring him up.
He's my walkthrough guy. He's out in the hallway. Let me grab him real quick.
You need a translator?
Yeah.
Okay.
I have to call them and let them know.
She can and she cannot. What's your question?
For the-
It's still in effect.
Right.
Correct.
Do I have
Yes.
to let-
Who?
May we approach on?
Yes.
Okay.
And what is your cause number?
Okay.
256-1688.
You get it?
I have it. I talked to Marcus.
Vasquez, right?
Yes, Your Honor.
Okay. You are Kevin Vasquez.
Yes, Judge.
Mr. Vasquez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you.
Yes, Your Honor. On April 14th, 2025, in Harris County, Texas, law enforcement officers assigned to a follow-up investigation for failure to stop and give information. The complainant advised law enforcement officers that the defendant pulled out of a parking spot and struck the complainant's vehicle in a Chick-fil-A parking lot. Complainant advised that the defendant left the scene without providing any information. Law enforcement officers went to the Chick-fil-A and found surveillance footage of the incident. Store manager stated that they recognized the defendant as one of their store employees who was on shift that day. Store manager provided the defendant's contact information. Law enforcement officers arrived at the defendant's residence and spoke to the defendant's mother, who confirmed the defendant had been driving the motor vehicle that day, but her husband was the registered owner. Defendant contacted law enforcement officers, provided his Texas ID and insurance information, and admitted driver of the motor vehicle on the date of the accident. Defendant stated he drove out of the parking lot and felt an impact, did not see anything on the ground, so he left and went home. Defendant stated he did not call the police or file a police report.
Okay. Can you run his license, please?
Yes, Your Honor. And one other thing, Your Honor, we did get a damage estimate back, just for the damage purposes.
Oh, how much? Right.
$5,000.
It's, yeah, we'll talk about that, Judge, and we've watched the video and a lot of pictures of
I mean,
damage.
it always depends on the car.
That's incorrect.
Lambo.
That's why. It's Audi, but it's a 2013 Audi. So I don't know, and it may be. So we'll figure it
I
out.
think we'll be able to help.
Insurance?
I'll find out. I don't know if he has insurance, but I'll
So
find out.
according to the DIMS, the defendant had turned his insurance information over to law enforcement. I'm going to talk to the complainant, see if there was anything filed, and maybe we do something with the deductible.
Sure. Do you see if he has a license?
Yes, Your Honor. I'll.
Not allowed to drive, Mr. Vasquez, unless you have a valid Texas driver license and liability insurance in your name. That is a part of your bond condition. If you pick up another case, if I find that you're driving without either, I will revoke your bond and put you in jail. No more PR bonds. Do you understand?
Yes, Judge. It's eligible, Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with Marcos and he'll tell you if and when you have to come back to court. So do you mind filing those conditions and then we'll sign it? We're going to have conditions for you to sign. Once you sign the conditions, after that, you'll be free to go.
You're right. That's just they're driving without a valid Texas license and
And no,
insurance.
and no insurance, right? So we need a bond because it's in warrant status now. Roxanne, do you mind giving me a PSR? Do you want the cause number? You have it? Okay. I don't know if I see anything. If barring no criminal history, I'll set the bond at $100. I'm going to give you a PR bond now. But like I said, you will not get any more. This is your one chance. You understand?
Yes, sir.
Are you still employed at that Chick-fil-A? So he's going to have a ton of paperwork to sign. We'll have you go to Victoria, sign a reset now. Do not leave until you sign our bond conditions. Then you have to meet with Roxanne for your PR. Okay, thanks, Mark. Appreciate it. Okay, just punch down. You step, do you have the cost? I'm also finding that there's probable cause to go forward on your assault case, and I'm barring you having any contact with this complaining witness. There is a protective order that has been issued in this case.
As the man speaks and breathes with anger, witness the tight, tense courtroom where he's charged with assaulting his own family and a driver left helpless in the car. Will his powerful testimony be enough to tip the scales, or will the so-called white jade words save the day? Don't miss the courtroom drama and the final decision that could change the defendant's life forever. As the man speaks and breathes with anger,
You are here, Guzman?
Sorry.
Mr. Guzman, you're charged with two cases. You're charged with assault of a family member. You're also charged with driving while intoxicated. On the assault case, you're facing up to a year in jail and or a $4,000 fine. And on the DWI, you're facing up to jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you. Okay.
Thank you, Your Honor. On April 29, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle with an expired registration and initiated a traffic stop. The law enforcement officer made contact with the defendant driver and observed a strong odor of alcoholic beverage. The defendant admitted that he had an open container of an alcoholic beverage in the back seat and admitted to drinking 2 to 3 beers.
While driving?
It's not clear as to when the drinking occurred. I'll check further in the dim summary. The law enforcement officer found an open 16-ounce Miller Lite can, half empty and cold to the touch under the driver's seat. The law enforcement officer observed the defendant to have unbalanced and a strong odor of alcoholic beverage. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant consented to providing a breath sample and blew a .112 and a .111.
Okay, now we have an assault, right?
Yes, sir, that one is open. And we need
Whoa, so that was an open case.
They open warrant for a few months, non-arrest.
Okay, do you mind reading me what happened on the assault, please?
Absolutely, Your Honor. On March 1st, 2025, in Harris County, Texas, officers were dispatched to a family assault. A law enforcement officer met with the complaining witness who stated that the defendant is her ex-boyfriend. The complaining witness stated that they got into an argument over the complaining witness's inability to make him a sandwich. The complaining witness tried to stop the defendant from leaving, but the defendant closed the door on her hand. Later, the complaining witness was holding her child when the defendant bit her, causing bite marks and a bruise. The complaining witness stated that the defendant has assaulted her before, but she never reported it.
Mr. Guzman, I'm going to find that there's probable cause to go forward with your case on both cases. I am ordering you can you look to see any prior DWIs, please?
Yes, Judge.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I would think that it's freaking elementary that you're not to have alcohol in the car while you are driving. I am now taking away your privilege to drive. You are not allowed to drive for any reason. I don't care where you have to go. I don't care what you have to do. I don't care that you have to work. I don't care if there's a burning building and you have to save 50 kittens. You get into a car and drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. If you do, every single time that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand me? I'm also finding that there's probable cause to go forward on your assault case, and I'm barring you having any contact with this complaining witness. There is a protective order that has been issued in this case. Get to know it, because if you do something to violate the protective order, the state can and probably will file additional charges against you. A violation of protective order, and that is the capital murder of misdemeanors. Mr. Guzman, I'm going to protect every single person in this county, whether they're on the street, whether they're on foot, whether they're on the house. And if you become a danger to my community, I only have one place for you. And I don't know who you have in this life, but if I put your bond at 10 to 20,000, if you don't have anyone to pay it, you will be stuck like Chuck in there until these cases are over with. Do you understand?
Yes, sir.
Any prerogative, yes?
No, Your Honor.
Okay. Mr. Guzman, do you have the ability to hire a lawyer? I can have you fill out an application. I need to know everything about you. How much money you have coming in, what you're doing, what kind of car you have, any kind of retirement. I need to know everything about you, and then we'll take a look to see whether you qualify. Don't be a danger. Do you understand?
Yes, sir.
You get no more warnings. All right, Deputy Miranda.
Yes.
You are giving up the right to a trial,
Derecho a
right to compel witnesses to testify on your behalf, confront and cross-examine your accusers.
Don't let a glass of wine deodorize the future. Watch the dramatic trial of two dangerously drunk drivers as project reports and commission warnings highlight the deadly consequences of drinking behind the wheel. Can relaxation weight loss really sway the verdict? Or will this bone-deep lesson be a wake-up call for those left behind by the law?
Jamal Williams is upstairs. He's going to plead to a 7-year probation with inpatient. They're going to dismiss the case once they get it. I'm at 256. I don't know if you want to just roll it till they dismiss it.
Pleading upstairs, right?
But they're in trial, so we probably won't plead until like 1. So I don't think you still.
Roll it.
As soon as I get confirmation, I'll,
Roll it. We'll roll it to tomorrow.
Okay.
And,
if I get confirmation, I'll.
Okay.
we actually, and just to give you a heads up, on his probation case, he owed, what, like $160? We just satisfied it so he wouldn't have to go pay it or a warrant would issue.
Okay.
So I think, did we satisfy? Do we terminate? Oh, that's what it is. Okay.
So we'll probably have to come to you.
Okay.
Now you won't be on. Go ahead and go to inpatient. So.
Well, he's done here with us. So we'll just run it concurrent, I guess, with the other ones, right?
Okay.
Yeah. All right. Good morning, Mr. Hernandez Ramos. I don't know if you watch the news, but every single day, perhaps every other day, someone dies in our county from an alcohol-related incident. It's so not fair. All you have to do, if you want to get loaded, is hit one button on your phone and you can have a car take you anywhere you want to go for 50. You've now over and over back here for this foolishness. You now need to understand that it's out of my hands from now on. You're pleading guilty to both of these DWIs. They will both be going on your record. If you ever have the faintest smell of alcohol and you come into contact with an officer, from now on, you are looking at a felony offense, a minimum of 2 years in prison, a maximum of 10 years in prison. Is sending you to prison the way that we're going to have to get you to wake up? Look at me. Do you have to go to prison? Is that what it's going to take? All we're asking you to do is don't kill someone, man. Take an Uber. And if you're going to, don't have alcohol in the car. You now stand charged with 2 counts of driving while intoxicated. Both of those are elevated to Class A misdemeanors because of the high blow. You are facing up to a year in jail. The agreement that you have worked out is 60 days in jail with credit for 4 days that you have done on both of those cases. Both of these will be going on your record. So the next time it's a felony offense. You understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. By pleading guilty, you can never come back and change this or challenge this. Do you understand?
Yes.
This is what you want to do.
Esto es lo que ustedes.
Sí.
Yes.
What have you learned?
¿Qué has aprendido? Nothing.
You don't know what you're not supposed to do in the future?
Yes.
What are you not supposed to do in the future? I want to make sure that you understand.
I don't have to drink.
I don't care. If you want to drink, don't get into a car. What did we just learn?
Aprendiste solita.
Que no tengo que meter, si tomo no me tengo que meter.
If I drink, I don't need to drive.
I'm going to suspend your ability to get a license for 2 years. Do not drive until you get a license. Did he say guilty or no? How do you plead to the office, guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow the agreement. Good luck to you, Mr. Hernandez. Thanks.